Pocolaw is a Vietnamese law firm located in Hanoi, dedicated to providing personalized legal services and practical advice to our clients. Whether representing clients in court or in a transaction, we aggressively advocate for our clients' interests and provide skilled, efficient service. This video discusses about investment forms, specializing in multiple member LLCs as outlined in the Enterprise Law 2020, providing guidance to investors in deciding which type of enterprise to establish. Per the Investment Law 2020, foreign investors or enterprises with a certain amount of foreign ownership undertaking a project are required to complete investment registration formalities before the relevant provincial-level State Investment Registration Authority, SIRA, which will issue them with investment registration certificates, IRC. Per the Enterprise Law 2020, every enterprise must receive an Enterprise Registration Certificate, ERC, prior to beginning operations, which will be issued by the Provincial-Level State Business Registration Authority, SBRA. The ERC sets out the corporate details of such enterprise, including its amount of charter capital. The specific scope of business activities that an enterprise is permitted to undertake in Vietnam will be recorded on the National Enterprise Registration Information Gateway for public research. Foreign investment projects in Vietnam can take the form of any of the following investment vehicles: the Limited Liability Company, LLC, the Joint Stock Company, JSC, the Partnership Company, PC, the Business Cooperation Contract, BCC, Public-Private Partnership, PPP projects. An LLC may take the form of either an LLC with 2 or more members, Multiple Member LLC, or an LLC with 1 member, Single Member LLC. In the section below, we will clarify about Multiple Member LLC. An LLC has its own charter, and board of members, BOM, have the right to establish dependent units such as branches or ROs domestically or abroad. An LLC has the status of a recognized legal entity, and a member of an LLC is responsible for the debts and liabilities of the enterprise to the extent of the amount of capital that the member has contributed or committed to contribute to the enterprise. An LLC does not issue shares. A multiple member LLC is an enterprise that has more than 1 but no more than 50 members, which may be organizations, individuals, or a combination of both. A member of a multiple member LLC has the right, among other things, to A. Attend meetings of the BOM, B. Cast votes in a number that is proportionate to its capital contribution, C. B. Distributed shares and profits proportional to its capital contribution, and B. Given priority in contributing additional capital. Subject to the right of first refusal, that is, members wishing to transfer all or part of their capital must first offer to sell such portion of capital to all other members proportionately. A member can transfer, dispose of, or ask the company to buy back its capital contribution portion in accordance with the enterprise law or as stipulated in the company charter. The BOM is the highest decision-making body of a multiple-member LLC, and its members are appointed in proportion to their respective capital contribution portions. The chairperson of the BOM, or a member or group of members that own 10% or more, or a lower percentage as stipulated in the company charter, of the charter capital, the default minority members, can call a meeting of the BOM. In the event that the company has 1 member owning more than 90% of the charter capital, and its charter does not stipulate another smaller proportion for the default minority members, the minority members acting jointly will automatically have the right to call a meeting. A quorum is established when members representing at least 65% of the charter capital are present, or a higher threshold as stipulated by the company charter. If the first meeting fails to have the necessary members to constitute a quorum, a second meeting may be convened within the 15 days following the first meeting, and the second meeting must have members representing at least 50% of the charter capital or a higher threshold as stipulated by the company charter. If the second meeting does not meet the quorum, a third meeting may be held within 10 working days, at which time the meeting is conducted irrespective of attendance. The company charter stipulates the frequency of BOM meetings, but the BOM must meet at least once a year. Resolutions can be adopted by means of voting at a meeting, seeking written opinions, written resolutions in lieu of a meeting, or by other methods as provided in the company charter. by electronic means, such as video conferencing. Resolutions will be adopted at meetings when such resolution is approved by a number of votes, representing at least 65% of the total contributed capital of the members attending the meeting, or a higher threshold as stipulated by the company charter, except for when such resolutions would require a higher voting threshold as discussed below. A resolution on any of the following matters will be adopted at meetings when such resolution is approved by a number of votes representing at least 75% of the total contributed capital of the members attending the meeting, or a higher threshold as stipulated in the company charter. A sale of assets property with a value equal to or greater than 50% of the total value of assets, as stated in the company's latest financial report, or a smaller proportion stipulated in the company's charter. A resolution on an amendment and supplement to the company's charter, or a resolution on the company's reorganization or dissolution. A resolution adopted by means of seeking written opinions must be approved by a number of members representing at least 65% of the charter capital or a higher threshold as stipulated in the company charter. A multiple member LLC must have one director or general director of the company appointed by the BIOM who may or may not be a member of the company. The general director is responsible for the day-to-day operation of the company and is often the legal representative of the company, although the charter may provide otherwise. In conclusion, a multiple member LLC is a type of business that combines the flexibility of a limited liability company with the ability to cooperate with many members, while limiting the liability of members to the scope of their capital contribution. The collective management mechanism and restrictions on the transfer of capital contribution are unique features compared to other types of companies. What do you think? Let me know in the comments below, and don't forget to like and subscribe for more clips from us. Thanks for watching.